Session number 24 of the series on military law pertains to summary court-martial. This session would explain and highlight the essential processes and features of a trial by summary court-martial. Section 116 of the Army Act lays down that a summary court-martial may be held by the commanding officer of any corps, department or detachment of the regular army, and he shall alone constitute the court. It means that any corps means a particular regiment or battalion for this purpose, or there may be a department like the Judge Advocate General Department, or there may even be a detachment of the regular army which is deployed, which is located at a place where it is secluded, and then the commander of that detachment becomes the commanding officer for the purpose of these provisions. And proceedings, though conducted by the commanding officer, are required to be attended throughout by two other persons who may be officers, JCOs, or one of either, means one officer, one JCO, it may be two officers or two JCOs. They are present. They do not constitute the court, but their absence may vitiate the trial. Proceeding further, what are the powers of a summary court-martial? It can try any offense punishable under the Act, and insofar as the jurisdiction with regard to punishment is concerned. It may try any person other than an officer, JCO, or warrant officer. That leaves only the non-commissioned officers and other ranks who may be brought to trial before a summary court-martial. It can award any sentence as long as it is limited to 1 year rigorous imprisonment or below. So it cannot go beyond 1 year imprisonment. And if the CO, commanding officer of the accused, is of the rank below lieutenant colonel, then instead of 1 year, he can only award up to 3 months rigorous imprisonment. For the proceedings, the relevant provisions are in Army Rule 106, 107. Proceedings can be recorded in Hindi or English. Usually they are recorded in English. Evidence is recorded in a narrative form. Care being taken that actual words used should be recorded. Or the other option is it can be recorded in the form of question and answer. Question to the accused or a witness, and what is his answer. This is taken down verbatim, and the procedure allows the use of an interpreter if the language of the accused or any of the witnesses is not known to the court. There is also a provision for a person to assist the accused. He is called friend of the accused. He may be a lawyer or may be a non-lawyer. His role, this is very interesting, his role is to advise the accused on all points relating to the trial. He can suggest questions to him if a witness is being examined, and the accused can be advised by his friend that ask him this question. But the friend of the accused cannot himself cross-examine any witness or address the court. So the communication permitted is only between friend of the accused and the accused. Before the proceedings start, the court is sworn. It takes an oath. Interpreter also takes the oath. What oath will be taken down is indicated in Army Rule 109. I will just read out to you. It says, I so and so, I swear by Almighty God that I will well and truly try the accused or accused persons before the court according to the evidence, and that I will duly administer justice according to the Army Act without partiality, favor, or affection, or if any doubt shall arise, then according to my conscience, the best of my understanding, and the custom of war in such cases. If any witnesses are to be examined, then the oath is taken when witnesses are also called in the courtroom, and the idea perhaps is that it should impress upon them the solemnity of the occasion, that you are under oath. So this matter, the situation is serious. One accused, if there are more than one accused, then one court can take oath to try all of them in succession or as the situation is. After the court has been sworn or affirmed, the next stage is arraignment. Then the process of objections and amendment to charge. These we would see one by one. Arraignment is the reading out the charge to the accused. He should know what is the fault that he has committed in terms of law. So the charge on which the accused is arraigned shall be read. If he can't understand, then it will be translated and explained to him. And he is also asked, if there are more than one charge, to plead separately to each charge. For example, the first charge relates to theft. Then he is asked, are you guilty or not guilty of the charge? So his answer has to be guilty or not guilty. If he keeps quiet or remains silent, then a plea of not guilty shall be recorded. Then maybe the second charge is for absent without leave. That is read out, and again accused is asked, do you plead guilty to this charge or not guilty, and so on. Accused has a right to object to the charge that it does not disclose an offense or is not in accordance with the rules. There may be a situation that a charge has been framed, and supposing that discloses no offense, so the accused may say, so what? What wrong have I done? Which act section has been violated? To cater for such situations, it is written that accused has an option or a right to object to the charge on the ground that it does not disclose an offense, or it is not in has not been framed according to the rules laid down, and amendment in such a situation to the charge is permitted, and the provisions in that regard are in Army Rule 113. There is also a provision for an accused to raise a special plea which could relate to clean bar or on the jurisdiction of the court. Now, plea in bar may relate to, yes, I have done this charge, I am guilty, but I have already been punished, or the offense has become time barred. So, like this, plea in bar can be raised, or general jurisdiction can be raised, that this court does not have jurisdiction because I do not belong to this unit, or any other ground which impinges or which relates to the jurisdiction of the court. After that, there can be only two situations: accused pleads guilty or not guilty. It is to be remembered that if there is more than one charge, then the plea of the accused shall be recorded in respect to all such charges. And if I already said, if he does not plead, keeps quiet, or talks something irrelevant, then it is recorded that the accused has started shouting, or he has become silent, does not speak, and court decides to proceed on a plea of not guilty. Before a plea of guilty is recorded, accused is to be cautioned in terms of Army Rule 145(2), and that states that accused would be told that, look, this is the charge against you. When you are saying guilty, it means the court will take no evidence. It can proceed on your acceptance. So this explanation or this advice is tendered to the accused, and depending upon his answer, then the court proceeds. What can be his answer? He may decide to change. He may say, okay, I'm not guilty. So if it is not guilty, the witnesses will be examined by the court. After a plea of guilty, then procedure is little shorter. The summary of evidence is read out and is annexed to the proceedings. It becomes a part of the proceedings. Accused is allowed to address the court in reference to the charge or in mitigation of punishment. However, if having pleaded guilty, in his address to the court, he says something which indicates as if he is giving an explanation and he is actually not guilty. So then the plea of guilty shall be changed to not guilty, and the court will proceed. Essentially, the difference between guilty and not guilty plea is that in guilty, the court is not required to hear any evidence because the accused himself is admitting that he has done the charge. On the other hand, when he says not guilty, then the proceedings are recorded by examining the witnesses. Therefore, procedure after plea of not guilty, evidence for the prosecution is taken, one witness, second witness, like that. And at the close of the case for the prosecution, the accused is asked if he has to say anything in his defense. At that stage, he may call his witnesses, who would be called defense witnesses as opposed to prosecution witnesses earlier. And then there is a stage for the court to question the accused for the purpose of enabling him to explain any circumstances appearing in his statement or in the evidence against him. So if there is any contradiction or mismatch in what the witnesses have said and what the accused is saying in his statement or in his answer to the court questions, so he is allowed an opportunity that how do you explain this? This is what you have said, but this is what is coming in the evidence. Would you like to explain the discrepancy? However, no oath is to be administered to the accused. Thereafter, the stage of Army Rule 119 and 120 comes in. Witness in reply to defense and verdict, the accused or the witnesses may be called by the court in the interest of justice in reply to the defense. Supposing the accused, in his address to the court or the defense witnesses, bring out such a situation that there is a need for court to clarify its mind whether the accused is guilty or not guilty, so the court may call some other witnesses to clarify that situation. After that, the court records its finding or the verdict, and the verdict is simply written as guilty or not guilty. The charge, say, of absence without leave, the accused is not guilty or the accused is guilty. And finding has to be recorded separately in respect of all the charges which are there in charge sheet. Usually there would be only one charge, but supposing there are more charges, then for each charge the finding is recorded whether the accused is guilty or not guilty. Then in case if the accused has been found not guilty, then he has to be acquitted, means he has been allowed to go. Court shall date and sign the proceedings. Proceedings are announced in the open courts that the accused is not guilty of the charge, and then with regard to those charges he is released, he is set free. On the other hand, if the accused is found guilty of a charge, then the court may record either the presiding officer, commanding officer himself, or may take evidence about the general character of the accused. And this character relates to the military character, that previously he has a spotless career. He has never been convicted earlier, never been punished earlier. Or there may be a situation that he has already been punished many a times. What is his age? How much service has he put in? What is his rank? if he has been honored with any gallantry award or for the distinguished conduct, and in case he has been previously convicted, then record of previous convictions is kept, which may be by a civil court or by court martial or under section 80 relating to summary disposal, and the number of days for which he has already been under arrest or confinement. That before this case took place, he has already been in custody awaiting trial for 20 days. So this period is written, and the reason is that this pre-trial detention is set off against the conviction which, if any, is awarded to him. Then is the stage for award of sentence, punishment. So even if there are more than one charges, the court will award only one sentence in respect of all those charges to which the accused has been found guilty. It is not a case that for each offense there is a separate sentence. No, only one sentence for all the charges put together, and then the presiding officer puts his signature, puts the date, and this signature and date authenticates the complete proceedings that they were done and now they are over. Thereafter, the sentence is promulgated. Now, promulgated means a parade takes place, and in front of the parade, the accused is brought, and all others are told that this was the charge against the accused. He has been found guilty or not guilty, and he has been sentenced, and then the sentence is carried out. Means if he is dismissed, then he takes out his uniform, goes out of the unit premises. If it is awarded imprisonment, then he is transferred to the place where he is going to be detained. There is also a provision under Army Rule 132 that promulgation can be deferred. Now, this is only in situation where the commanding officer has less than 5 years service. If the commanding officer is relatively young in service, junior, then the sentence is not carried out unless the proceedings have been approved by the superior authority, except in case of active service. If there is active service, then this need not be deferred and sentence may be promulgated straight away. If a summary court martial carries out trial of an accused in a manner which ordinarily should not have been done. For example, accused had done an offense with regard to the commanding officer, or the offense was very serious, should not have been tried by STM. But if it has been done, then the commanding officer spells out reasons why the needs of discipline wanted prompt action. And this memorandum is attached to the proceedings, and the law in this regard is contained in Army Rule 130. Proceedings thereafter are reviewed by a superior authority. Now, this is provided under Army Act Section 162. So, after promulgation, the proceedings, the documents are forwarded through the Deputy Judge Advocate General of that command to the officer who's empowered under Section 162. It is written there. Usually, it is the brigade commander who's the immediate superior of the commanding officer, and he goes through the proceedings to see whether there is any illegality. This way, having seen the procedure of a summary court martial, which obviously is based on reason, which is fair, reasonable, it is to be appreciated that the instrument or the tool of summary court martial is frequently invoked to maintain a speedy discipline and early disposal of the cases under the Army Act. Till 2007, there was no appeal, but after an armed forces tribunal has been constituted, there is now an opportunity of a meaningful defense to the accused where he can exercise his right of appeal. Thank you.